Good afternoon, everyone. Allison Skyberg here. We are here today with the week's law firm and Rachel Dickison. There's no in the middle where I'm sure people mess that up all the time, Rachel. But anyway, today we are going to be talking about wills and trust and guardianship. We've got a lot of content today to get through in a short period of time. So just want to go over a few housekeeping items. I always do. We are in webinar mode today, and that means that we can't see you or hear you, but we do know you're here, and we are glad that you're here with us today. We do invite you to put your questions in the chat box as we're going through the presentation. We'll be getting to just as many questions as we can throughout the time that we have together today. So, Consolidated Planning Group, I know a lot of you are here and you've attended our webinars in the past. Some are probably clients. We are glad that you're back with us. But Consolidated Planning Group, for those that are joining for the first time today, we are a holistic special needs financial planning firm. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. So our whole firm is nuanced in planning for a loved one with a disability for their future. And a lot of times there's a lot of confusion on what, like somebody like Rachel and her firm, what they do and what we do. So I always shorten that up, short and sweet, is that they're the paper and we're the money. They're the legal documents. You got to have them. Super, super important. We don't do what they do, and they don't do what we do. So when it comes to having the right people on the team, you got to have different members at the table. And the financial side is like, how much money do we need to fund a special needs trust? How and when do we apply for public benefits? How do we preserve state and federally funded programs such as SSI and Medicaid? So we help people open ABLE accounts. We solve, those questions, such as how much do I need to fund a special needs trust? And we also pave a way for a path for a family that's saying, gosh, that's a lot of money. How do I retire and stay retired for 25 to 35 years? I have other kids, they're going to go to college, might get married, things like that, and then still have enough money to fund a special needs trust. So we help people figure those things out as well. So having said that, I'm going to just move ahead and turn things over to you, Rachel. Again, today's webinar is being recorded. Everybody is going to get a copy of the slides today and a link to the recording, and all of our recordings live on our YouTube channel after the fact. So if you need to go back to one, we have over 400 webinars on our YouTube channel on planning for special needs. If you can think of the topic, it is definitely out there. What I will mention is, because we're talking on several topics today, is the legal documents, the special needs trust, and the guardianship. If you're wanting to take a deeper dive into each one of those topics, I do invite you to go out to the YouTube channel and check that out. And I know that we've had multiple presentations with Rachel as well as Trustee Weeks as well. So Rachel, thank you so much again for being here with us, and I'm going to let you take it away.
Thank you so much. Like Allison said, I'm going to be doing an overview of all these different topics, so it might be helpful for you to look at the slides afterwards, because there's going to be some information that I'm going to be skipping over. But we're going to go over the top 10 questions that I get about wills, special needs trusts, and guardianship. So we're going to skip ahead a little bit to my topic about wills. So, as part of estate planning, you have a lot of different options. So you can go to the next slide. Thank you. Um, we have a lot of different options for how we can manage your estate. But really, looking at estate planning, this is how you want your property to be distributed after you pass away. So, looking at who you want to give it to, how you want to give it to them, and when you actually want to give it to them. So it encompasses a lot of different areas, but this is really important for our families that have a special needs child, because you have to think about the future and what's going to happen next steps if something was to happen to you. And the big way that we do that is we make sure that we maximize the government benefits that they're going to be able to have. And we're going to also plan for who's going to step into your role that you have as parents and become that person that's caring for your child. Next slide, please. All right, so we do this through a variety of different documents. The most common one that you may have heard of is a will or a special needs trust, but we also want to make sure you have a comprehensive plan. So we do that by having a declaration of guardian, and this determines who is going to be the guardian for yourself if something was to happen to you, but also the guardian for your child if they would be unable to make those medical and financial decisions that they need to make for themselves. We also set up beneficiary designations to make sure that your whole plan is comprehensive and it really goes where you want it to go. And we're going to also make sure that you're planning with your other family members, making sure that we're not going to have any disqualifications from those government benefits. We also want to make sure you have your powers of attorney in place. And I'm going to talk about a little bit what those are when I get to my guardianship topic later on. All right. So, before I start talking about special needs trusts, I think it's important that we all have a foundation in the different government benefits that are available for our young adults with special needs. So, the one you've probably heard of the most commonly is supplemental security income. And this is $943 per month at the maximum amount this year, used for food and shelter. Now, as part of having SSI in Texas, you can also receive Medicare. So you'll receive, excuse me, Medicaid. So you'll have health care. But there's also Medicaid waiver programs, and they provide additional services like attendant care, therapy, different supplies that you might need. So there's a lot of programs out there that can help you. On the next slide, I'm going to talk about the different requirements. So for SSI and Medicaid, there's three different things that you need. So one is you have to have a disability determination. You also have to have low income and limited resources. It's important to note for the Medicaid waiver requirements, they have different eligibility requirements. So those are not quite the same as what we're going to be talking about right now. So for the income and resources, you have to have less than $2,000 in resources and less than $2,000 in monthly income. So let's go to the next slide and I'll show you a little bit more what that looks like. So for SSI, for that you have what's called substantial gainful activity. Basically, what you need to know about this is that the monthly income for SSI is 1,550 for an individual per month. Now, for Medicaid, that limit is $2,000. And that's why if you're receiving $1 of SSI, you'll actually also receive Medicaid. Now, income looks like food and shelter, although that's changing a little bit today, and I'll talk about that in a second. But food and shelter, cash, and then any asset that can be converted to food and shelter will be considered income for that individual. So let's talk about that rule that's just changing. So in-kind support and maintenance is considered to be income. This is when someone else provides food and shelter for that individual. Now, as of today, rule is changing. So Social Security has changed it from food and shelter to just being shelter. And so we're still looking at how this is actually going to be applied. But from what we're told, the things that will be considered to be that are rental income, mortgage, utilities, property taxes, all those things are encompassed in shelter. So if someone else provides that to your individual with special needs, then they could receive a 1/3 reduction in their SSI amount. Now there's ways and strategies that you can avoid having this 1/3 reduction. I've listed out some here, but in the interest of time, we're going to go to the next slide and we're going to talk a little bit about resources, and you can look at other presentations about those reductions. Now, for resources, you have to have less than $2,000 in countable resources. What's not counted is a home, a car, any personal items, furniture, clothing, things that they have, or a 529 education account. So the things that do count against them are any typical bank accounts, uniform transfer to minor accounts if they're over the age of 21, any investments or real estate that they own that's beyond that one home. Right. And another program that I want you to be aware of, it's a little bit different than SSI and Medicaid, but when a parent passes away, or if they start taking their own Social Security retirement, they may be eligible for a program called Disabled Adult Child. So if the child was disabled prior to age 22, And usually what they look at is that disability determination that they make whenever they're doing the SSI. They could be eligible for half of their parent's Social Security check. And so they could receive that benefit whenever the parent passes away or when they start taking Social Security retirement. Now, the wonderful thing about this program is that after being on this program for 2 years, you can be eligible for Medicare, which, as you may know, is taken by a lot more physicians. So it's really beneficial, and you may be able to have eligibility for not just Medicaid but also Medicare. All right. Now, an important note on Medicaid waiver programs, there's a whole bunch of different resources that you can learn about all these waiver programs. What I want you to know is if you are not on the Medicaid waiver lists right now, I would look into more of the resources about that and how to get on those lists because they have a really long wait list period that you need to get your child with disabilities on them as soon as possible. All right, so we're going to switch over to talk about special needs trusts next. All right. Oh, thank you. So the next point for SSI and SSI and Medicaid, those are what we call needs based. So they have requirements on income and resources. For SSDI and for Medicare, there's different requirements, and so they're not needs based. They're based on, just your eligibility requirements.
So I just wanted to comment on the Medicare because we did have a question on the qualifications for Medicare. So I just a quick summary. SSI, Supplemental Security Income, comes along with Medicaid. But later, when your disabled adult child, like the parent either turns on Social Security disability or Social Security retirement, and you apply for disabled adult child benefits under your record or a parent's record, after 24 months, they will be eligible for Medicare. It's an automatic enrollment. So if they're disabled, once they're deemed disabled, either under their own record or under a parent's record, once you've turned on that Social Security, the disabled adult child, not SSI, then they're eligible for Medicare. So otherwise, and it's always 24 months following, like once you've been deemed disabled. Otherwise, it's age 65 for Medicare. And then the last piece of information that I wanted you to know is sometimes you don't know this because you only do this one time. You'll get a notification that they're getting dumped off of Medicaid. They get to keep Medicaid. It's DAC Medicaid, MEPD, DAC Medicaid. Most cases, most oftentimes, you're going to have to do a new H-1200 form for the Medicaid application. So if you get something in the mail saying that they're canceling their Medicaid and you need to do the H-1200, you really do need to do that form and get that in. So I just wanted to mention that. So then they're dual eligible for Medicaid and Medicare. Medicaid is always the last payer. So if you have primary group health insurance, that's going to be the primary payer, then Medicare, then Medicaid. And sometimes there'll be a flip flop if you have all three, where Medicare will be first and then the group health plan will be second. It has to do with how many employees work for that company. So I just wanted to mention that, and let's just see if there's any other clarification there. Okay, no other questions at this time. So thanks for that.
All right, so we're going to transition into special needs trusts and about how those work in conjunction with government benefits. Now, another question that I frequently do get is, do I truly need government benefits? I would recommend that you get on the government benefits if you're able to, because sometimes, the government benefits are, it's something that you have an option to have, and it's good to have that support and that provided. Okay. All right.
I also just wanted to mention that all of the waivers are Medicaid waivers. So they do require Medicaid eligibility. So some families, to your point, Rachel, think, who even cares about 943 a month or SSI or whatever? But you do want to keep them Medicaid eligible because of those waivers. And depending on the level of need of the individual, I mean, some of those waivers are in excess of $300,000 a year. Now, it does go based on the level of need. But what I would say is, you're looking anything that's, 40, 50, 60, 100, $200,000 a year. That's significant. And that is a big amount that's not going to come out of your retirement buckets in the future. So I think it's important.
All right. So with the special needs trust, the wonderful thing about special needs trusts is that they provide additional resources for your child with disabilities. So often the government benefits are insufficient to cover the care for your child. And so we want to make sure that they are eligible for those government benefits and they have extra resources on top of those government benefits. Now, it's important to note also if they receive money outright from you, they could be disqualified from receiving any government benefits, and that's where a special needs trust comes in. So they're really beneficial for a variety of different reasons. Next slide, please. All right, so a special needs trust is not considered to be a countable resource. It has to have certain terms in it from the Social Security Administration, but the purpose of all of it is that once have the special needs trust, the government benefits provide for everything that they are able to provide for, and the and the special needs trust is there to supplement anything that the government benefits don't provide for. And the result of this truly is that your child's every need is going to be taken care of. We're going to set up a plan to conserve all of the resources that you need for your child, and they're going to last for a longer period of time.
So we had a question that says, does the SSI requirements change once the child turns 18? And so the answer is yes. So if you were denied SSI before, it's because the income and asset requirement, they're testing the parents. If you have a child under age 18, it's based off of your adult child with disabilities income and asset once they turn 18. So I like to remind families, even if you've been denied before, go back to the well once they turn 18, but you do want to make sure that you've got the money in the right buckets, that they don't have more than $2,000 in their name outside of an ABLE account or a special needs trust. And I know Rachel kind of hit on this, but also if you have child support, which in Texas, oftentimes, if there's a divorce situation, child support will continue post age 18, and you're going to want to have that money redirected to a first party special needs trust. But I'll leave that for Rachel. So definitely once they turn 18, things change. And that's true even if they're under full guardianship, even if you claim them on your tax return, even if they still live in your household, it's based off of their income and assets, not yours at age 18.
All right. And thank you so much for that. That insight's really important. I think we need to skip through, or we're right. Oh, okay. Sorry. Lost my place for a second. So, the benefits are not the only reason why we want to have a special needs trust. If you have this trust, but for some reason your child is not on government benefits, it can operate as a regular trust that you would have, and the trustee will manage the distributions for your child and help with any distributions that they might need, any financial support that they really need. And really, what that does is provide flexibility for changed circumstances. Depending on what your child's able to do, if we're going to plan for all the different possibilities. And that's the wonderful thing about a special needs trust. All right, next slide, please. Thank you. All right, so there are two different types of special needs trusts. You probably have heard of special needs trust in a general context, and most people are thinking of a third party special needs trust. But what a first party special needs trust is when it's created with the individual's own money. So it comes from a couple of different sources. One is an inheritance that they receive outright. So it doesn't name a trust in the will. It says that it's going directly to that child with disabilities. It could be child support, or it could be their own personal savings that they're saving up for work. Now, the important thing with a first party special needs trust is there's a Medicaid payback provision. And this is because it's created with the individual's own money. So any money that's left over in this trust after that child passes away, they will have to pay back Medicaid for anything that Medicaid has paid for them during their lifetime. And so that's paid out before it goes to any of the beneficiaries that you name. Now that's contrast for if a third party special needs trust. A third party special needs trust is created with someone else's own money. So that third party trust with all of the previous money, it goes to that it goes to that child. There's no Medicaid payback provision. So it's truly a wonderful resource. We use it with a lot of people that have an inheritance because they want to leave all that money to their child and not disqualify them from government benefits. And they're going to be able to leave all that money. And then after that child passes away, since there's no Medicaid payback provision, it goes to whoever your beneficiaries are, whoever you want it to go to.
Can you confirm what slide you want me to be on? I
Yeah, it's a
apologize for
couple
that.
further. Yeah,
Okay.
I think it should be 1 or 2 more, I believe. Yes. 1 more after that, and then, see. I think it's forward 2 slides because I just talked about third parties. Okay, next slide after this one. Thank you. All right. Now, the next question I get commonly is how do we make sure that money gets into this trust? So there's a variety of different types of assets that you can use. The most common one that I see is that you use your will to leave money to that child after you pass away. So you can set up your will that it goes and names the special needs trust. And typically that's a third party special needs trust, again, because that's creating with your money, not the child's money. Another way that you can fund it is life insurance. A lot of my families find this useful. Then retirement accounts, they have their own special benefits that I'm not going to have time to cover today, but retirement accounts can be left to a special needs trust. Sometimes grandparents and other family members want to leave a gift to that child with special needs. You can have that go through a third party, but child support is a little bit different. So, in the next slide, I'm going to talk about child support and how that changes. So what we're going to do with all of those different types of assets, we're going to have a funnel that everything gets gathered up and it goes into the special needs trust. But it's a little bit different with child support. So next slide, please. So with child support, like Allison mentioned before, after age 18, it counts against the child as income. So any child support they receive, it's going to just decrease their their SSI. So for example, $950 of child support can result in a total loss of SSI and Medicaid. But the way that we have it where the child will not lose their benefits, the child the divorce decree must order that any child support for that specific child needs to be paid into a special needs trust. Because it's considered their own money and their own income, it has to be a first party trust and it does have that Medicaid payback provision. So we can't prevent that, but a lot of our families use this because they have child support for that child after 18 and they want to make sure that they still qualify for those government benefits.
Rachel, one thing I think that is important that we talk about, a lot of people have affluent parents or affluent grandparents that
Mhm,
want to help their grandkids.
mhm,
And their advisor is not nuanced and special needs. So when they say, I have this grandson and I really love and I want to help him, he's on the spectrum and blah, 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 they say, great, what's his name? And
mhm,
that's how quickly they are accidentally named directly as a beneficiary as opposed to their third party special needs trust. So I just like to say that it's very important, and I know a lot of law firms actually have a document of how to talk to your parents about this. I know we have one too. But it's very important to have intentional conversations with any family members that may possibly leave your disabled loved one money so that they want to do it right. They're not trying to do it incorrectly. And it's not that their advisor isn't smart, they're just not nuanced in special needs or public benefits, and they don't understand some of these things.
mhm. Yeah, and I recommend that even if you don't think that your sister, for example, might leave money to your child, you still have that conversation because you never know what their plan is going to be. So just have that conversation so they know that if they leave anything to that child, it's going to go to them outright and it's going to cause a lot of issues. All right, so if you don't have a special needs trust, what's that going to look like? So sometimes they don't receive any inheritance at all from their parents. If that occurs, then they will only be limited to their SSI, their Medicaid, anything that government benefits provide for them. If they inherit those assets outright, typically what happens is either it would have to go into a first party special needs trust, which unfortunately has that Medicaid payback, or in some cases, they don't talk to an attorney and they have to spend down all of that inheritance in the first couple of years, spend everything down, and then they're left with just government benefits. Or sometimes what we see is they leave assets to other family members, but we can't guarantee that the other family member is going to use it for their care and use it for everything they need. Or even if you have someone that you trust to spend that money, that we can't guarantee that they're going to live beyond the child with special needs. So we strongly recommend that you have a special needs trust in place because it truly sets up the care for your child. Next slide, please. All right, so we're going to transition into a different topic. So we're going to be talking about guardianship. So as you might know, whenever a child turns 18, any child, not just a child with special needs, they gain a lot of rights and abilities within their within society. So they have the ability to make their own decisions about their finances, their education, medical decisions, where they want to live. They're going to have the full range of decisions that are available that you, as a parent, didn't that you had before. So whenever that child turns 18, they may be vulnerable to predators. They may not fully understand all the decisions that they have to make. And that scares a lot of parents, especially with the ability to sign contracts, to get leases, credit cards, get themselves into debt. It's kind of scary for a lot of parents with special needs children. Next slide, please. So, one of the things that you should be thinking about in the guardianship process is, are they going to be able to manage their own care? What if they can't make those decisions for themselves? Typically, what a judge in a court's looking at is, can they manage their own finances and can they manage their own medical care? Do they need assistance evaluating all those decisions, or do they just really need someone that's going to make all the decisions for them because they don't understand those financial and medical decisions at all? Okay. So, guardianship is a court created relationship between two individuals. You can have two guardians if they're the parents or if they're married. There's certain situations. But the terms that I'm going to be using, so the person that needs help is called the ward or the proposed ward. And the person that gives the help to that individual is called the guardian. So the court is the one that decides if the proposed ward is unable to manage any of their personal, medical, financial affairs. They're the ones that make that decision, and it's court created relationships. So they make all of the decisions about this. Now, if the court decides that they're unable to manage all of their affairs, then it'll appoint a guardian or co guardian, and it takes away the civil rights of that individual with special needs. So typically what they're looking at is all of their different decisions about things that happen in their day-to-day life. And what we call this is substituted decision making. So the guardian is the one making all the decisions for the proposed ward. Next slide, please. All right. Now, it's important to note in Texas, but all over the nation, there's a growing legal trend away from guardianship. So, this has impacted how the guardianship procedure works in Texas and what actually happens at the court level. And so, the goal of this movement is to allow our individuals with special needs to have more civil rights. The effect on this is there's a lot more requirements for guardians as they're going through the guardianship process. And a strong example of this is for anyone that's in special needs or any receiving any special education. They may not need a guardianship. It's no longer assumed that they have to have a guardianship. Next slide, please.
I just have a question about this because I know that this is a trend all across the United States, but it also lends itself to some people not being under guardianship that truly should be under guardianship. So can you talk a little bit about that? Like for a person, like if they cannot do anything for themselves, they cannot be left alone. If the parents both died tonight, the kid would be in real trouble. Is that an example of somebody that probably really does need? I mean, I think it goes really far right and really far left, and
Yeah.
somewhere in between there. I mean, there's truly people that truly do need guardianship. So will you just talk about that for a second?
Of course, and integrate that into my next slides as well as I'm going along. Guardianship, it really depends on the individuals and the court based on where you're at. So an individual that truly needs that support, that's going to be someone that you're going to want to have guardianship. Um, in some courts, I'm not going to name any particular courts, but some courts, there's something called less restrictive alternatives. I'm going to talk about in a minute. But some courts want you to try those less restrictive alternatives, see if it doesn't work. And then if it doesn't work, then they'll appoint the guardianship. So it really depends on the judge in the county that you're in, what they're going to decide. And in the whole process, it is a good legal trend, but it does make things more difficult for our adults that truly really need guardianship. And it's very apparent to us working in around special needs individuals all the time. And you as parents working with those individuals. But there might be more evidence that you have to provide to the court, and that's just something to be aware of as you're going through this process.
So we have just a couple of quick questions. Can we apply for guardianship without a lawyer? And I don't think you can in Texas, can you? Or
That's
tell us how that
yeah,
works.
that's correct. So in guardianship proceeding, it has to be done by an attorney. We actually have to have a training course. So every attorney that does guardianship law has to take a 6-hour course on guardianship. And so they're aware of all the legal implications. It's one of the few areas of law that you actually have to hire an attorney for. You can't do it but yourself.
And honestly, I think it's such an important, there's so many things when it comes to planning for special needs. And I think the legal side of it, I think it's truly, truly important that you work with a specialist because our situation is specialized. It's really, really important to work with an attorney that's really nuanced in this. The next question was individuals that truly need support and can easily be proven by documentation. How soon after guardianship is applied for is it typically granted? What's the turnaround time?
It really depends on the county themselves. So just to give you a little bit of background on how the courts work in Texas, just very, very briefly. In the 10 biggest counties in Texas, there are something called probate courts. So they only focus on probate cases and guardianship cases, in some cases, mental health. In those cases, you may be able to get it a little bit quicker because they are specifically working on those areas of law. If you are doing something where it is a county court, a smaller county, they may take a little bit longer. To give you an idea, I'm up in the Dallas area, so I practice in Collin, Denton, and Dallas. For Collin County, it's about 6 months after the application is filed. For Dallas and Denton, I would say 9 months to even a year, possibly. To give you a little bit of peace of mind, a lot of my families, if they've applied after the child turns 18, and if they show whoever they're trying to get documentation from, the doctors, the schools, if they show them a letter saying that they applied for guardianship, typically those people will be able to work with them, and they'll have a working relationship even after that child's turned 18. We haven't had any issues with, you've applied for guardianship. We're waiting to hear back. I haven't had issues with that. I know it's a big thing with the timeline. Okay. All right. So I'm going to skip back and talk about the different types of guardianships for you. So the main important thing that for you to know is there's two main types of guardians. The one that you'll typically hear of and you'll think of is the guardian of the person. So this is the individual that makes all the medical decisions and the living arrangement decisions for the individual with special needs. So if it's this, there's an annual report that has to be filed to the court, but after the guardian of the person is appointed, you shouldn't need to hire an attorney later on in the process. Now, guardian of the estate, they handle the property and finances of the person with disabilities. Now, it's only if that person has significant assets. Typically, that's looking at more than the $2,000 amount. And there's additional reporting required by the court. But I'm going to talk about some other options that we have. Remember that the court's creating this relationship, so they have to monitor it along the way and make sure the guardians are doing their job. Next slide, please. So there's also another distinction, which is total guardianship and partial guardianship. So typically, the rights that can be retained by the individual with disabilities are the right to drive, to vote, to marry, or to determine their personal residence. So if they want to retain any of those specific rights, they'll have what's called a partial guardianship. They can retain just one, they can retain all of them. I've had cases where it's been one, I've had cases where it's been all of them. Um, if they don't retain any rights, it's called a total guardianship. Now, a temporary guardianship, you're unlikely to have the situation unless there's an emergency, but it's where immediate action is needed to take care of that person. And it's for a very limited period of time. We're talking, 14 days, a month, at the most for that temporary guardianship. All right. Now let's talk about less restrictive alternatives. So these are part of that legal trend that we're talking about. The goal is to make sure that that person is going to be as independent as possible, and they're going to be able to make as many decisions for themselves as possible. So for guardian of the person, there is several different alternatives. One is medical power of attorney, and a HIPAA release. So this allows the person with disabilities to make their own medical decisions, but if something happens to them, their parents will be able to step in, or whoever your proposed person that would be the typical guardian would step in. Now, there's also a durable power of attorney. That document is effective immediately. So it allows for the individual with disabilities, they can make their own financial decisions about opening a bank account, investments, opening up a credit card, for example. But the person that would typically serve as guardian, parents, siblings, whichever is your situation, they would also have the authority to manage the bank account, help with budgeting, things like that. And so that's really useful for a lot of our young adults that are higher functioning, that they can make their own decisions, but they can also have support when needed. And there's also supported decision making. I'm going to talk about that a little bit by the next slide, whenever we get after we do the guardian of the estate. So the guardian of the estate, you can have a representative payee for the Social Security check. Typically, for our young adults with disabilities, this is the only income that they're receiving. And so appointing a parent to serve as the representative payee is sufficient where they don't need to have a guardian of the estate. Now, another way that they can do it is having a special needs trust. So the trustee is going to manage all that money for them, make any expenses, pay any bills they need to have. Or you can have a joint checking account with your child with disabilities, and that would allow them to not have to do guardian of the estate. Typically, in almost all of my cases, we don't need to have a guardian of the estate because these least restrictive alternatives are really useful for them. All right, next slide, please.
And I think I heard in the last week or two, and I don't know when it went up, but it's up to 20,000 now. Like you don't really need a guardian of the estate as long as the assets are below 20,000. So not even the 2,000, it's gone up to 20 in Texas. But I will say, because we do work with people all across the United States, it's different in different states on that. Whereas in Texas, we mostly don't see very many guardianships of the estate, whereas other states, they do it simultaneously, guardianship of the estate, guardianship of the person. So it just depends on what state you're in.
Yes, and in September 2023, the law changed to allow the guardian of the person, they can apply to manage funds up to $20,000. And so they have to actually apply to the court and they have to be bonded. But it's a great option if you have less than $20,000 for that child to have those assets managed for them. And so it's really useful. And we haven't had the opportunity to do it yet with our firm, but I'm sure it'll come up soon. All right, so supported decision making. So Texas was the first state to create supported decision making agreements, and a lot of different states are able to do this now. If you're in a different state besides Texas, I would look at that website and see if your state offers it. But in this, the person with the disabilities is called the decider, and then they have a person called the supporter. Typically, that's the parents, but whoever would typically be the guardian. And that supporter helps them gather up any information, determine pros and cons. They understand all the options that they have to be able to make their decision. And the decider is the one that makes that decision. So it can help with where to live, medical decisions, any supports and services that they receive, where they want to work. And so after the decider decides on all of these different decisions, the supporter is the one that communicates it to other individuals. Now, there's a written agreement, it's a state form, and it has to be signed and notarized by both the person with disabilities and the supporter. But the person with disabilities has to understand the benefits, the risks, and the consequences behind each decision. Next slide, please.
I just want to talk about that just for a second. So we see a lot, a supported decision-making agreement in line with the least restrictive, most appropriate. But having that supported decision-making agreement, power of attorney, healthcare power of attorney, what can happen when, so our kids are going to sign whatever we put in front of them. If you tell little Johnny to sign this, he's going to sign it if he has the ability to sign. But it doesn't mean that he necessarily understands what he's signing, which you just hit on that for a moment. Can you explain what the problem is, what the potential problem is when you have a child that really does not have capacity
Of
signing these documents?
Yes, of course. In my next slide, it should be talking about the advantages and the disadvantages between these, because it's supported decision-making agreement. It's great if it works for that child, but it doesn't work in a lot of different circumstances, because, like you said, the child may just sign whatever's in front of them, and they may not truly understand what that decision works with. Every time that I talk about powers of attorney and supported decision-making agreements, I talk about this with the families and say, do they truly understand what the decision is they're going to be making? And will they ask for help with making all of these decisions? Because it can be a lot for that child with disabilities to make those decisions they might need. So the advantages of them, they are in control of their own decisions. They still have their civil rights and they have someone that's there to help support them. And the way they can also have some freedom and some self-determination for their own individual ability. There's a lot of advantages to making them feel like, they're in control of their own life. The disadvantages with supported decision making and the powers of attorney is there's no court supervision over any of this. So you can't control who is going to be the individual. I mean, you're going to set those documents up, but any individual can come and set up a supported decision making agreement with your child. So there's a potential for conflict between the child with disability and with the individual with disability, excuse me, between the supporter and the decider. There could be conflicts between the two of them. There's also a potential for abuse. If someone comes in and wants your child to sign those documents with them, they will have the authority to make those decisions for them. The other issue with this is we've had issues with our clients being able to have someone honor those agreements. Excuse me. So sometimes they'll take it to the doctor's office. The doctor's never heard of supported decision-making agreements and says, no, I will not accept this. This is not something that I will accept. And so there's some issues with that, and some education efforts are going to increase the ability to use the supported decision-making agreements. There's a lot of educational component that comes along with this, but a lot of times it may not provide the care and protection that you need for your child with disabilities. So it's really great when it works, but a lot of times it won't work for that child with disabilities. All right, next slide, please. All right, so with guardianship, once that guardianship is granted, there's different powers depending on if you have the guardian of the person or the guardian of the estate. So if you have the guardian of the person, their job is the day-to-day needs and abilities and cares that the child with disability has. So their job is making sure that all needs are met. They determine where they live, they determine medical treatments and options for them, where they work, different educational decisions, and then who has access to the proposed ward. That has all of those decisions. With the guardian of the estate, they're going to handle all of the ward's money, investments, property. Again, this is out for a certain amount. We talked about the less restrictive alternatives, but if they have a little bit more money, they handle all of that money and take care of it. They use the money for their ward's care to pay their bills, anything that they have. And then they also can sell property that's in that child with disability's name with court approval. They can also enter into contracts with them, and they can also sue on behalf of the guardian of the estate. So a lot of times this is not necessary, again, for our children with disabilities, but it's really useful if you do have these types of situations. Next slide. Thank you. So a guardian, there's a couple of things that they can't do. Guardianship will not work in these circumstances. So one of these is the guardian cannot place a ward into a mental facility. That is a separate mental health proceeding that happens through the court. It's not the guardianship process. They also cannot force medication for that child with disabilities. And so that's a big limitation on guardianship. And they don't have to take responsibility for any of the illegal acts of the proposed ward. If they do something illegal, it's not the guardian's responsibility. It's the proposed ward or the ward's action. It doesn't fully protect them from their bad decisions. So you can't fully protect them from everything, but it does provide a good layer of protection for them. And then the guardian also does not have to pay for the ward's own debts with their own money. All right, next slide, please. All right, now I talked a little bit about this before, but the guardian of the person, it renews every single year. There's an annual report. Typically, you find it on the website for the county court, whatever, if it's a county court or probate court, whatever it is for your county, you'll find that report form on their website. And then for the guardian of the estate, it's a little bit more intensive. So you have to file an inventory of all of the assets of that individual with disabilities, and they have to file an investment plan. They have a specific bank account set up for that child or that individual. And then they have to ask the court's permission to spend any funds, buy any things, or sell any assets for them. So looking at all of this, what works for your situation? Is guardianship appropriate, or should you consider the less restrictive alternatives? So really what we want to look at is guardianship fully necessary to care for and protect that individual with disabilities? Can they make decisions in their own best interest? Can they provide for their food and shelter and their abilities, the things that they need to have? And are they vulnerable to being taken advantage of if they don't have the protection of guardianship?
So we had a question. I'm going to keep it generalized.
Mhm.
In the chat box, what if you feel like somebody who is under guardianship, they're not under your guardianship, but they're under guardianship, and you feel like they might be being taken advantage of financially? How do you go about reporting that? What happens if that is something that you suspect? What does the person do?
So there's two ways that you can report a guardianship that you think they're being taken advantage of. One is you can report that guardianship to Adult Protective Services through the state of Texas government. They investigate cases of abuse specifically for adults. Another option that you have is if you know the county or the court that guardianship is underneath, you can report it to that court, and they have individuals that work for the court. They're called court investigators. They also have court visitors. And what they will do, if you report them, or even if you think someone might need a guardianship, you can report them to the court. And the court will send someone out to meet that ward so they can see, are their needs truly being met? Is someone taking advantage of them? And if that is the case, then the judge will revoke the right for that guardian to be the guardian. They'll call them to a hearing, ask them to explain themselves. So that's the two big options that you have. APS is really good if you don't know exactly the county or which court it is. The APS option might be really good for you. Okay. All right, and then on the next slide, if you guys want to look at this later, this is some specific different examples that we see that a lot of our families, they have concerns about these areas. And if you have concerns about a lot of these areas, you might want to lean towards guardianship and not towards the less restrictive alternatives for your individual. Okay. All right. And then what we also look at as part of the decision-making process, not only with mere meeting with the attorney, but also what the judge looks at is, are there any alternatives to meet that child's needs? This is a requirement under the law. We have to look at have I done everything possible to make sure that individual maintains their independence and their decision-making abilities before I file for guardianship. So we're going to talk to you about this multiple times to make sure that we're really doing the right thing. All right. Now, our last question is, when do I need to take all of these steps? So the first one, when do I need to create a special needs trust? We say prior to your own death or your own disability. So I know that's kind of generalized. You don't know exactly when that's going to happen. If we knew that, if you had a crystal ball, it would make life things a lot easier to plan for, right? But because we don't know when that's going to happen, whenever you're comfortable, you're ready to have these conversations. Sometimes our families need to save up a little money to hire an attorney. Whenever you're ready to have those conversations and figure everything out, then that's when you would want to have those conversations. Whenever you're ready as a family, the sooner the better. But it can be a lot to have these conversations. So whenever you're comfortable, go and see a special needs planning attorney. And now it's not related completely at all to guardianship. A lot of my clients do come in whenever they are doing a special needs trust. They also do a guardianship at the same time. Now, doing to start the guardianship process. For our firm, you cannot have, well, backing up a little bit, you cannot have the hearing for a guardianship process until after the child has turned 18. So for our firm, we say about 6 months before, set an appointment with us. And it has to do with some of the reporting requirements. There's a medical exam that they need to do. It has to happen 4 months before we file for guardianship. And so we say about 6 months before is a great time. Come make an appointment and then we'll go from there. All right.
Can we just talk about like IQ and intellectual disability? Like, the general consensus is, you hear 70 or below, 69 or below,
Mhm.
75 and below with multiple disabilities. Those are all three things that are thrown around pretty regularly in our state. Um, so is there a threshold, a generalized threshold where we're thinking that the person may not have capacity to understand what they're signing?
Yeah.
We talk about that?
So there's no true threshold. It could be they could have something higher. I will say from experience, if your child is around 80 in IQ, generally we're doing the powers of attorney. If not, because you're not, if even if you're on the fence and you're not sure, a judge will see that IQ and say, I'm not sure. Let's try the less restrictive alternatives first. So we like to try the less restrictive alternatives first and then do the guardianship. You're not going to be penalized for that if you do that. I mean, we don't have a hard and fast cutoff with our firm, but I would say generally around 70, 75 from what I've seen. But a lot of times my clients just have an estimate of IQ. They don't have a full diagnosis, or it's been 15 years since they've had that looked at, and so they don't know 100% what it looks like. I say if you're concerned about it, have a meeting, figure out if it's going to work for you, and then we can decide. We can drill down to specific situations and what might occur and see if guardianship is necessary or if it's not.
Okay, we have two great things in the chat box. Is it better to create an actual special needs trust now, or can you have one created upon your passing? I'm curious. I have an opinion on that, but I'm curious how you feel about that.
So it is completely possible to have one created upon your passing through your will. I strongly recommend that you have one funded, or if you create one that's outside of your will. The reason why is if anyone else wants to leave money to your child with disabilities, they can name your third party standalone trust and all the money can go to there. So they can have everything separate. Also, I didn't touch on this a ton, but there's retirement account benefits to leaving it to a standalone first or third party special needs trust, and that you have more advantages for that. So if that's only something that you want to just put it in your will, I think that's great because they're still going to have the government benefits, but it's not the full spectrum of protection that they could have. And I recommend that it's standalone.
So I agree with that 1,000%, and on all of those points. And the only other point that I would add is when it's standalone, that is the quicker that the child's needs can be met upon the passing of a parent. If it's got to be established after the parent dies, we're dealing with funeral, we're dealing with estate stuff. It takes time to get the documents set up. So that's the other reason that I would suggest that. So here's another big one. This is a great a great comment question. Basically, it I lost it. Hang on. If we plan, this is so good. If we plan to switch from partial guardianship to supported decision-making agreement, How far in advance should the supported decision-making agreement be set up before the guardianship expires? And I was under the impression, Rachel, that in Texas, even though you have to renew your papers every year,
Mhm.
that guardianship is in place until there's a court order not having it in place anymore. So you can't just willy-nilly decide that your child is not under guardianship anymore, like that you're going to move. The court has to agree with you on that decision. Is that correct?
That is correct. So remember what I said before, is that it's a court-created relationship. So the court has to decide if any changes are going to be made to that relationship, if guardianship's going to be there still, or if they're going to completely, it's called restoration. If they're going to do a restoration of that guardianship, the court has to be the one that restores the rights of the proposed ward. Give you an example of this. Whenever you take away the right to drive, the court will send paperwork from the court's office to the Texas Department of Motor Vehicles, and they will actually put a hold on any ability to get a driver's license. So, in order to have everything reversed, the court has to be the one that sends something to the Department of Motor Vehicles to take that off. So, there's a lot of different things happening behind the scenes. You can't just decide Unfortunately, you can't just decide it yourself. You have to go back to the court to modify.
Okay, and so one person said that they're actually in another state in Michigan specifically, and that their partial guardianship expires in 5 years. So this is going to be state specific.
Mhm.
It's going to be very state specific, and for our state, it's county specific. So if you've got guardianship of the person in Harris County and you move to Bear County, then you're going to need to update all of that. It's very specific to the state and to the county and to the provisions of that particular state and how they roll with these terms of guardianship, partial guardianship, etc.
Mhm.
And
Definitely.
so, and in that example, so let's give one more example because we see housing, we see where families may have their loved one living in a housing arrangement. So maybe mom and dad lives in Houston, and now they've moved. The individual with the disability is now living in Dallas County, for instance.
Mhm.
Is that an example where that guardianship would need to be updated since the individual has moved counties that way?
Yes. So the guardianship is based on wherever the person under guardianship resides. So if they move counties, then you have to transfer the guardianship. The guardian can even be out of state. They can be in a different county, they can be out of state. It's going to be based on wherever that person resides.
Okay,
That's
that's
what
good.
disabilities reside.
Okay, so the guardian actually could be out of state. There's no issue with that.
No. And I've had a group of parents. One parent lived primarily in Texas, one parent lived in another state, and they were able to get guardianship.
Perfect.
Okay. All right. So just to wrap up, if I have any more questions, I'd be happy to answer them. The result of wise planning truly is that your family is going to have a lot of peace of mind. So we're going to have a financial plan to set up for your child. We're going to have a plan with the special needs trust on what that's going to look like. We're going to have a built-in support team in place for that child after you pass away. We're going to provide instructions for their care. One of the things that we do is we ask you to write down all of your intentions on what you think trust funds should be used for and how you think your child should be cared for after you pass away. We're going to ask you to write everything down. You're also going to retain your eligibility for any government benefits. And then overall, we just want to make sure that you have a really fulfilling life for your child with disabilities. And this is going to help them set up for success and that you don't have to worry about their future. All right.
So good. We just have just a couple of other questions in the chat box I'm going to run through. One question is, do law firms offer bundled packages for special needs planning? And it depends. It's very dependent
Very
on the
specific.
firm specifically, and the fees are kind of a wide variety. But I have seen a lot of packages in that. And here's a great question. Is a special needs attorney needed for the custody child support agreements? Generally, yes, but not the Weeks law firm. Like there are firms that are nuanced and divorce and child support. And we know of even some attorneys that are nuanced and special needs child support matters. But when you need to get that child support redirected to a first party special needs trust, it's not the estate planning attorney that does that. They may set up the first party special needs trust for you, but the other attorney is who's going to get the court order ordering it to that first party special needs trust. So that is unfortunate that you need to. A lot of people have asked about discounted services or things like that. All states, I don't care what state you are in, there are services for the indigent and low income. Disability Rights Texas is one, but if you Google legal aid and you type in your county for guardianship, you will find the ones that are in your area. I know the Catholic Charities in Bexar County, there's like 12 counties in the greater San Antonio area that does free guardianship. I know that there's free guardianship in Galveston, but you have to live in Galveston County, right? Like there are a few programs that have like a grant where they're doing free guardianships. They are few and far between in the state of Texas. But there are those legal aid societies out there, and of course, reach out. We're happy to provide, referrals. And of course, the Weeks Law Firm is awesome. We know they're awesome. We've been working with them for a long time. So, but get those documents in place, figure out a way to get those documents in place and, plan accordingly financially to get those documents in place because it's truly important when it comes to your planning journey. So Rachel, you are awesome as usual. So thank you for being here with us today. Today's webinar has been recorded. You're going to get a copy of today's slides and the link to the recording. If you're listening to this on podcast and you would like a copy of the slides, just email us at contact@cpgcares.net. We've got all kinds of webinars on that YouTube channel. We serve families all across the United States, not just in Texas. We are domiciled in Texas, but we do serve all across the United States. So these are just a few things that you're going to want to keep on your radar. Texas waivers are Medicaid waivers. All states have them. It doesn't matter what state you're in, they all have them. Understanding SSI, SSDI, knowing when and how to apply. ABLE accounts. Beneficiary designations we really hit on, but the bottom line is on this, we say this almost every webinar we have, do not name your disabled adult child as a beneficiary on anything you have. And instead of that, have a third party special needs trust for the benefit of said child, and then it's going to preserve that eligibility. So you're in our slides, you're going to get a link to our upcoming webinars. And so you can sign up for any of the upcoming webinars that might be relevant to you in the journey that you're on. We work on a collaborative team here at CPG. We stand ready to work with you and help you plan for your future. This QR code on the screen, you can hover your camera over that, and that'll take you to a calendar where you can schedule a free personalized consultation. Sometimes people have deeper questions. They want to go deeper. They didn't want to put it in the chat box. We are happy to talk with you further about your specific journey. One person I just wanted to comment before we end today, ask about if you have a specific document that you share about how to talk to families. I know that we have one that we share with our clients. I don't know if the Weeks Law Firm has one about how talking to families, but one thing I would like to say is one of the things that we say is starting the conversation, because a lot of our parents or grandparents, they're very private about financial information. They don't like talking about this. It's kind of a taboo topic. We don't talk about it. But one way to open the door is saying, I've realized I've really got to look at finances and make sure I've got money in the right buckets to preserve eligibility for said child. I've been learning a lot about special needs trust and guardianship and all these things. And I actually learned that we could really mess little Johnny up by accidentally leaving money in the wrong place. And this is what I've learned. And this is what I'm doing about it. And I realized I didn't, we've never had this conversation. So I just wanted to share with you what I've learned. And it kind of just opens up the door. So do you talk to us about that, Rachel, really quick before we end for today?
Yeah, I don't have anything that specific. We talk about it every time we sign any documents with clients, but we don't actually have a piece of paper that we have. The only thing I have is really I direct them the actual language of their trust, which is going to be individual for based on whatever you're doing. But I think what Alice was saying is completely the way to start that conversation, and just have it with everyone in your life that you think might be able to do it, just so that they're aware, because most people aren't aware of all of the different things that you're going through as a special needs parent, and what that actually looks like. So if you're looking at all of that, you're letting them know, it's going to help a lot in the future that you don't have to have hire an attorney to fix things later on.
And you really just never know. You might have a little sister or a little brother who's not married and doesn't have any kids and loves their niece and nephew. And it was something as simple as when they were filling out their group benefits at work, and it said, who do you want the life insurance to go to, and then they put them down. I mean, stuff happens quickly, so just be prepared for that. Guys, you guys have been great and had great questions today. Thank you, Rachel, for always being awesome, and the Weeks Law Firm. Reach out to Rachel and her firm. Reach out to us. We're happy to help, and we look forward to connecting with all of you again soon. Thanks so much, and have a great afternoon.